Welcome back, everyone, to Collier Bristow's US-UK podcast, in which we hope to shine a light into the dark corners of the transatlantic wealth planning room. As ever, if you haven't listened to these episodes before, then I'd encourage you to do so. Previous episodes have touched on all manner of topics, and you can hopefully find them quite close to wherever you found this episode. On today's episode, we'll be looking at the issues of testamentary freedom and the circumstances in which an individual may bring a claim against the estate of someone from whom they were expecting to receive an inheritance but perhaps didn't do. We'll look at how domicile interacts with the ability to make a claim, and perhaps how those claims can either be avoided or frustrated in advance. Now, I have the pleasure and privilege of being joined today by Samara Dutton, partner at Collier Bristow and the head of our contentious trusts and probate team. Samara, thank you so much for coming onto the podcast. Before we dive in, would you like to introduce yourself and your practice?
Yes, good morning, Aidan. Thank you for having me. I think you've done a fairly good job of introducing me professionally, but in terms of my practice, I'm a litigator, so I deal day-to-day in disputes in the context of large estates or valuable trusts, basically advising executors, trustees, beneficiaries, any parties really, to contentious issues around those sort of backgrounds. So breach of trust claims, will challenges, rectification applications, anything along those lines. But certainly some of the most interesting matters to cross my desk are these applications under the 1975 Inheritance Act, where applicants are seeking to vary an English will or intestacy, because it is that act which is this jurisdiction's sort of main imposition on the otherwise inherent concept of testamentary freedom that we have here.
You've teed up all of the things we're going to talk about today beautifully. I mean, I always like to think about the fact that, we in the non-contentious section of the wealth planning community or the estate planning community are, setting up the house, making sure it's all built structurally and properly, and then Samara comes along when the house is on fire and helps you put the fire out.
Absolutely.
As long-time listeners know, I like a good hypothetical client in case we want to refer to them, and today is no exception. So I'm going to introduce you today to Mr. and Mrs. Adams, if we want to use them. Mr. and Mrs. Adams are here for us, and in the good tradition of this podcast, yes, Mr. and Mrs. Adams are named after former presidents. I'll let you decide whether that's John Adams, the second president, or John Quincy Adams, the second president, and his son. Let's imagine that Mr. Adams has died or is thinking about dying and is making his will, possibly thinking about cutting his son out for whatever reason. So that's the background if we want to use it. The things we're going to talk about today, we'll have a look at the topic that Samara already sort of referenced, testamentary freedom. What does it mean in practice for those looking to leave wills? We'll look at the 1975 Act that Samara touched upon, what the Act is, who can bring a claim, what the consequences are. We'll look at how the concept of domicile interacts with the 1975 Act, and particularly in the sort of the US-UK sector, how that bears out. And then we'll sort of finish off by looking at the ways in which certain things like trusts can interact with the 1975 Act to frustrate claims, and or what individuals can be doing now in their lifetimes to sort of ward off any claims. So turning to that first topic of testamentary freedom, it's a well-versed and well-understood topic in UK law that for the overwhelming most part, an individual has testamentary freedom. What does this mean in practice? It means that effectively you can leave your estate to whomever you, and more importantly for these purposes, you can cut out whomever you want. With sort of traditional nuclear families with a sort of spouses and children, most people want to leave their estates to their spouse and or to their children. And so these issues don't really ever arise. However, if you want to leave your estate to the next door neighbour, the milkman, a friend or a charity, then there's nothing stopping you from doing that. And it's in that sphere where these issues tend to arise. This is an issue that has been litigated time and time and again, and I'm sure if we wanted to tomorrow, we could talk about all the ways in which it's been litigated, but it's an upheld bastion of sort of will planning and estate planning that a person can leave their estate to whomever they want. Would you agree?
Absolutely. It's just historically accepted that in the English jurisdiction, there's no legal obligation to provide for your family in the same way that you have forced heirship provisions in other European countries or worldwide, etc. That's just part of our history and our makeup.
Is that a topic that is readily accepted? I think by the time that clients come to come to see you and say there's an initial discussion about whether a claim is to be made, or they're feeling aggrieved. Presumably that's a relatively low hurdle to get over because of how widely understood it is. And when they come to you, is it more about that they feel aggrieved and there's a sort of an idea of a lack of fairness or something's happened, rather than I didn't realise that I could be cut out if my dad wanted me to?
It varies, actually, Aidan. It's an interesting question. Although the concept of testamentary freedom is quite a clear-cut one, and one that, as you say, can be explained quite readily and strongly to a client, there is a sense that when they're coming to you with a claim, that the unfairness is born of a duty on the deceased part to do something for them. There is naturally, I think, in many children particularly, a sort of expectation that is built into them over the years where they've been provided for previously. So they sort of expect and feel that the law ought to uphold that expectation. And it can come as quite a surprise that it doesn't.
And in fact, you've alluded to one of the ways in which we can sort of help sort of head off some of these issues later, which will be clear communication between parents and children. You never want an inheritance to come as a surprise, or a lack of inheritance to come as a surprise. Better these things are discussed as adults during lifetime, because unfortunately, when people are grieving after death, that's not really the time you want to find out also that you've been cut out of your parents' will.
No. Because the emotions around that can just heighten difficulties and bring on litigation that might not otherwise exist. Having said that, these are difficult conversations to have, and nobody wants to have them, and nobody wants to sort of accept their mortality. So they often don't. And, as much as you can encourage people to have those conversations, I can understand why they often choose not to.
Yeah, and it's also worth pointing out, and it's again touched on the point you did also just make previously, the idea about international laws. And so when we're talking about testamentary freedom in the UK, it's important to recognise that the extent to which UK law applies to the assets of someone in the UK can vary. We in the UK have succession law that is governed differently depending on whether you have what we refer to as movable assets, which is everything except your immovable assets, and then your immovable assets are really your real estate,
your house,
your house, your property. So if you are a UK domiciled individual with a house in the UK, which most people in the country will be, then UK law will just govern everything that you own, and it will also govern things abroad as far as we're concerned. But if you are a non-domiciliary, if you've come here from abroad and you've settled here, but you've retained a domicile outside the UK, which we'll come on to later, then UK law will only apply for succession purposes to your real estate. So if you are, for example, an American, or from another country, it is the law of your domicile, let's say a state in the US, that will govern how we, the UK, will accept your assets get devolved after your death. Now, between the US and the UK, that's not really dramatic, because the US overwhelmingly has testamentary freedom like the UK does. I think, in fact, only Louisiana is a remaining state that has a degree of forced heirship rules. But if we had a client who was French, or if we had a client who was Saudi Arabian, take Saudi Arabia as a good example, in fact, Saudi Arabia operates Sharia law and applies Sharia law to a degree, which has very restrictive rules around what you can do with assets during your lifetime and or on your death. And so in this scenario, the issue of testamentary freedom is actually curtailed from a UK perspective quite severely.
Absolutely, yeah. We will respect the laws of the domicile of the individual that has passed away. And that can lead to quite complex cases and claims where you need expert witnesses on those laws in as far as they refer to assets that are held here, if there are arguments about it. I've definitely been involved in a sort of forum non-convenience, or which a sort of jurisdiction dispute over whether we should apply Sharia law from the UAE or UK law, and that in itself it's a preliminary point before you can even get to the grips with who's going to get what. It is an argument over which court has jurisdiction, and sort of more international and complicated family structures can lead to very complex claims and sophisticated legal arguments needed to be brought in before you've even started dealing with who's going to get the house. So yeah, they're very, very interesting points, particularly from a legal perspective, probably more so for us than for the clients who just want to know whether they will get what they think they're entitled to.
I don't know if you as a client want your lawyers to feel sort of really enthusiastic about the legal arguments or not. I mean, we're here on a podcast talking about tax matters and legal matters, so we clearly must enjoy them to a certain degree.
Exactly. I try to engender that kind of enthusiasm in my clients, but it's not always taken on board.
Slightly harder, I appreciate, in a contentious setting where someone's trying to litigate. I imagine that the emotions are slightly more different than in a non-contentious setting. So the question of domicile and how that impacts, which we've sort of again we've referenced, we'll come on to, I think, in the second half of this episode. But let's assume for the time being, we're taking Mr. Adams. Let's assume that he is a domiciliary here, and let's assume that Mr. Adams is a domiciliary here, and that is not in dispute. So the 1975 Act is potentially in point for his son. In terms of the Act, we tend just in the UK to refer to it, Samara, do we not, as just the 1975 Act. I do certainly, because I just can't remember its full name.
It has a full name. It is the Inheritance (open brackets) Provision for Family Independence (close brackets) Act 1975. But yes, 1975 Act is a lot easier.
It is. So in terms of who has standing and who can bring a claim under the 1975, am I right in saying that it is a closed class, a mostly closed class of people that can bring a claim?
Yeah, yes. The classes of applicant under the 1975 Act are prescribed by the statute itself and are relatively limited. They include spouses and civil partners, former spouses and civil partners, as long as they haven't remarried or formed a new civil partnership. There is a category of claimant where you've lived with the deceased for 2 years prior to their death, as if you were a wife or civil partner. So it does sort of cover sort of new modern relationships, if we can still call them that. Otherwise, it is children, persons treated as a child by the family of the deceased. So it's a sort of odd category of claimant, which doesn't necessarily mean that the deceased particularly treated them as a child, but if the family within which the deceased was part treated them as a child, then they may be able to sort of get in on the action, as it were. And the final category is any other person who was maintained by the deceased, either wholly or partly, immediately prior to their death. And obviously that is sort of open to some sort of interpretation as well, but it does leave this sort of more general category at the end that you may be able to shoehorn yourself into if you were being provided some kind of maintenance by the deceased before they passed away.
So I use the example of the cohabiting partners, the unmarried cohabiting partners, as one of those rare examples where UK law actually recognises unmarried partners having legal standing, because for tax purposes, for succession purposes, unmarried partners have very, very few rights. For example, under an intestacy, if an individual doesn't leave a will and an unmarried couple have a child, the child will inherit everything rather than the partner, even if the partner is the parent of that child. And so in those circumstances, that is one place where, a claim could be brought if the parent felt that they needed some provision rather than just their child. But is it not the case, Samara, that is a rare outlier of a time when actually non-married partners or those non-civil partnerships actually have some standing?
It's absolutely, and it is, I would suggest, somewhat anachronistic for the intestacy laws not to recognise these types of relationships. But for this specific act, which is only to be used in certain circumstances, to have been as sort of forward-thinking as it purports to be by having this category, what I would say is that even though there is scope for this category of claimant, so someone who has been living as a wife or partner, civil partner, for 2 years, at least 2 years prior to the death, although there's scope for them to bring a claim, they do fall under the less favourable applicants banner. So there is a distinction under this act between spouses and civil partners claiming and all the rest of the applicants. Spouses and civil partners are benefited because they get provision that is reasonable in all the circumstances. All other categories of claimant can only get provision for their maintenance, which can be quite limiting. So although we do recognise, that there are people beyond spouses and civil partners legally formed, that may need to make these claims, we do treat them still less favourably.
Yeah, and I think that probably that probably recognises the fact that if you have a spouse to whom you are currently married and you leave them no provision, that is probably one of the more dramatic circumstances, and thus why that category of claimant has probably a greater right to financial recompense than some of the other parties. There is a time frame, is there not, within which that claim also has to be brought. So you can't sit on your laurels and sort of 5 years down the line think, oh gosh, actually, I tell you what, I've changed my mind. I quite fancy some provision anyway. There is a relatively short time frame.
There is a time frame for bringing applications under this Act, which is 6 months from the grant of probate, or from the date of issue of the grant of probate. It's not an inviolable deadline. It is possible to bring a claim outside of that time frame with the permission of the court. If you miss the deadline, you are adding an additional hurdle to your claim that generally, you wouldn't want to do. But reasonably speaking, if you have acted, if there are good reasons for your delay, if you've acted promptly overall, if you've been in communication with the executors and other beneficiaries about the fact that you're likely to make a claim, and if the estate itself hasn't yet been distributed, then the court is likely to grant you that permission. It always depends. These cases inevitably depend on the specific facts. And so it's really hard to sort of give general rules for them. But overall, permission is likely to be granted if there's no prejudice to any other party, and as long as you have acted reasonably and relatively promptly. That is my view on it. Others might take a different view on it, and certainly in the right case, I would argue differently if it helped my client. But the 6 month time limit is not a firm deadline that will invalidate your claim, but it will make your life a lot easier if you can bring it within that time frame.
Yeah, no, I think it's as with most things in these kind of issues, promptness is rarely going to be a hindrance. Delay might, but it might not. It depends on, as you say, the facts of your case. To which you already made the point. These cases are very much done on a case by case basis. It's very hard to draw strict rules about the way in which these things will work or may work, because every single case is unique, and that goes to both the factors that the claimant has to show, but also the factors that the courts can take into account and the remedies that are available for the courts to provide in the end. Is that not the case?
Absolutely. It is almost impossible to extrapolate reasoning from one judgment to the circumstances of a different case. I mean, taking these cases from the beginning, what an applicant needs to demonstrate is that the will or intestacy in question has not made reasonable financial provision for them. If they can establish that, then the court will make reasonable financial provision from them. So we'll vary the will or the intestacy so that reasonable financial provision is made. Now, what reasonable financial provision is varies widely and is informed firstly by what category of claimant you had. As we mentioned earlier, if you're a spouse or civil partner, reasonable financial provision is what's reasonable in all the circumstances of the case. For any other category of claimant, what is reasonable financial provision is what is reasonable for their maintenance. Maintenance itself is a grey area concept. It is generally seen to be somewhere between sort of breadline provision and everything that you want. So what is important is the Section 3 factors, which is a list of factors under the Act which judges are directed to in establishing what is reasonable provision or whether reasonable provision has been made. Like, mainly, these factors point towards the financial needs and resources, either of the applicants or of anyone else that's a potential applicant under the Act, or of any other beneficiary of the estate. But also relevant is whether the deceased had obligations or responsibilities to any of these people, the ultimate size of the net estate, any physical or mental disabilities by any of the applicants or beneficiaries, And then the last factor, really helpfully, is any other matter which the court may consider relevant. It's been said these are not sort of hierarchical factors. The judges are supposed to sort of give each factor equal weight, but the result is that judges have a huge discretion under these claims to determine which factors will hold the most weight in any particular case. And that's why judgments become highly fact specific. And you can't really give general rules. So it's very difficult to advise clients from the outset that the prospects of success of these claims. Often you don't get all the information right at the beginning, and a lot more will come in that will change the weight of the case, basically, where you think things will go, and also depend on the judge on the day and what they make of the witnesses. So they are highly volatile claims, to be honest. You need to be quite careful in bringing them, and they are well suited to mediation and negotiation and settlement, because neither side can ever really know what the outcome is going to be.
I think one way in which those outcomes can sometimes feel uncertain, and the way in which those factors get applied in the public eye has been in respect of claims brought by adult children that are not common, I think, in terms of the number of claims that get brought, but are common in terms of the number of claims that get reported, because they tend to be the ones that are the most inflammatory. There was a very well-known case, I forget how many years ago it was now, the Ilott and Mitzen case that became Ilott and Blue Cross. Was it about 7 years ago?
Yeah.
I forget how many years ago it was now, but a case of an adult child who was of low financial means, but who was estranged from her mother, brought a claim, and it was found to be the court found in her favour and granted at the various levels that she was due financial provision out of the estate. And this hit a lot of the headlines because it was seen to be a child who was estranged from her parent, frustrating this concept of testamentary freedom. Now, this is probably something that you deal with much more frequently than me, but is it fair to say that those should be seen as outliers rather than any kind of trend towards a slightly more overreaching judiciary system, and that people should remain confident in the principle of testamentary freedom, just that they have to be aware that if there are people who would expect financial dependence from them, they should have due regard to those people?
Absolutely. I mean, Ilott Mitzen was, as you say, widely reported and sort of hailed as this horrendous outcome to the concept of testamentary freedom. In fact, I mean, it is, that case is the best guidance that we as litigators have on how the courts will apply the 1975 Act, because it went all the way to the Supreme Court. And I think we had hoped for slightly more guidance than was actually given. But in fact, if you analyse the judgments, they are still very respectful of the concept of testamentary freedom, and they still protect it quite heavily. In that case, one of the deciding factors was that the fact of the estrangement between the mother and the daughter was actually slightly on the mother's side. The daughter had made efforts to try and maintain a relationship, and it was seen that the mother was actually quite difficult, and that there was sort of some unfairness in her having disinherited her daughter. If you follow more adult children claim cases since then, the courts are still very strict in sort of adhering to this notion that if you have been provided for, if you don't need to be maintained at the moment, if there is no real need for your provision, then they will not necessarily make any award out of the deceased estate for you. So there was one case recently, I think Miles and Shearer v. Shearer, 2 adult children, one of whom had quite a severely autistic child, I think, and the estate was large. The estate was large and went in its entirety to his second wife, and these were children of a previous marriage. And so there was funding available there to help them, but they were seen more as the cause of the difficulty of the relationship. He had made provision for them some years previously. I think both of them had received somewhere between 170, 180,000 each. And he'd said at the time, that's it, you're on your own from now on. They brought claims in circumstances that, you could see on a particular day, a particular judge may have seen them as sympathetic claimants and might have wanted to make a award for them. But this particular judge didn't see that, thought that they were not in need of maintenance, and therefore the Act didn't apply. So they weren't awarded anything. So it is just fact specific. There is not a sort of judicial attack on the concept of testamentary freedom. In fact, very much the opposite. What they're looking for in the context of adult children claims is a need and something extra. That was specifically, I think, what Lord Hughes said in the Eilert v. Mitzing case. There needs to be something additional, some sort of moral reason why this child should be entitled to something. And that has been found in some instances and not in others.
I mean, it's if nothing else, it is a reminder to all of us that you should look beyond the headlines sometimes. You should look beyond the way in which these sorts of cases get reported. The judges will be looking at these things very, very carefully. These are experts in their field, and these things have been very carefully litigated. And the headline that might get produced by a broadsheet or a tabloid, sort of what they think the conclusion of this case is not necessarily helpful in terms of directing what the consequence of that case actually was. And so, those that are in this position or who are perhaps fearful of consequences of such a claims because of what they've read should take comfort from the fact that these things are litigated very, very carefully. That's not to say there aren't things that can be done to protect against these claims, and we'll come on to look at that a little bit later. But, always take what you read with a pinch of salt, I think.
Absolutely. I mean, it makes sense as a sort of saleable headline that, someone who you expressly stated should receive nothing has been given however many thousands of pounds. But yeah, it is not the nightmare that it appears to be, I think.
Particularly in cases like the Eilert Mitzing case, where was it not the case that the daughter was making a claim that would have reduced the estate going to a charity? And so in that particular case, it was seen as, by those in the press that sought to cast it this way, an entitled daughter looking to take money away from a charity, which only further heightened, I think, the mood and the tensions around the case.
Absolutely. I mean, it was surprising. You don't tend to find charities sort of taking court cases like that to the Court of Appeal or the Supreme Court because of the media coverage that comes with it. You don't. But absolutely, the charities had the sympathy of the media, I think, in this case, which is rare.
Yeah, we shall see next time it comes around. There will inevitably be a next time because the papers like to report on cases. That concludes the first half of this podcast. Thanks very much, Samara. When we come back, we'll be looking at what we can do to help clients who want to protect against those sorts of claims, and also when are these claims not even relevant? And that comes to the point about the part about domicile that we'll be looking at next. So come back shortly.